My name is Zach Jones, and I would like to welcome everyone here today to the Sealaska Heritage Institute's Native American Heritage Month lecture series. It's my pleasure today to introduce our speaker, Mr. Ed Thomas. Mr. Thomas is currently the president of the Central Council of Tlingit and Haida Indians of Alaska. He is on the Sealaska Corporation's board of directors. He is also a secretary with the Congress of American Indians. He's here today to speak to us about the interrelationships between tribes and corporations. He will speak to us, then we will have a question and answer session, and we would encourage individuals, if you have any questions, to please let us know, and we will bring you a microphone by so you can be recorded, because we would like everyone to share in this opportunity to hear from Mr. Thomas and ask him questions. It's also important that I briefly make note of our sponsors that have contributed this. It includes the Sealaska Heritage Institute, Sealaska Corporation. Some of the other sponsors include MRV Architects, as well as the McDowell Group and Kathy Ruddy. And of course, Mr. Thomas with the Central Council today. And so with that, I'd like to turn the time over to Mr. Thomas, and thank you very much.
Thank you, Zach. My Tlingit name at birth is Zahu, and I had another Tlingit name of Shanskadek, and I was honored with the Haida name of Skilquidons. I want to thank Sealaska Heritage Institute for sponsoring the series along with its other sponsors. I think it's very important for us to talk about the issues that are before us today. I listened to Mr. Malot's presentation last week and was impressed on his ability to bring about the discussions on ANCSA and the value that it has created, and also some of the dialogue associated with that. Today I'm going to be talking about tribalism as it relates to corporations, and I know that oftentimes there is misconceptions about tribalism in Alaska, and part of my comments are going to hopefully clarify some of those issues. When we look at tribalism, we need to really focus on the reality that tribalism is a federal term. It's a relationship between tribes and the federal government. In many states, they have established a relationship with tribes through their legislative process, but here in Alaska we have not done that yet. It is fitting that we talk about tribalism at this time, at least to begin my discussion on tribalism, as we're getting close to Thanksgiving. Most of you may be aware that when the settlers from Europe came to our lands, our people welcomed them. And when the pilgrims were struggling in the northeast of our country, the native people of that area reached out and assisted them to make it through the winter. That same attitude prevailed in our homeland, Southeast Alaska. When the non-natives came to our shores, our people welcomed them, mostly for the trade purposes, but also for other reasons. There was some good relations built early on, while there were still some struggles. I'm going to quickly go through some of this history, so if it seems a bit rushed, bear with me, because I do want to leave time at the end for some comments or questions. After the United States pretty much finished its struggle or became a United States, they developed the philosophy of manifest destiny. I don't know if many of you heard of that. From the native point of view, that became known as the American Indian War era. The idea there was that the non-native settlers would displace Native Americans across the country until the entire country was occupied and settled under non-Indian law. And so that is the general philosophy of the Manifest Destiny. It's an important concept because in the lower 48, when a war was completed with a particular tribe, they tried to settle their difference through treaties. Those treaties then became a methodology by which tribes were recognized in the lower 48. We don't have that kind of system up here in Alaska, mostly because the Indian wars had primarily ended by the time they became predominant up here in taking our lands. Instead, our lands were taken primarily through acts of Congress or executive orders. And so when we talk about the taking of land in Alaska, it was not taking our land through the settlement of a war. The Tlingit or the Haida Nation were never defeated in a war with the United States. It was taken through acts of Congress, as I mentioned earlier. As we ended the 19th century and moved into the 20th century, the United States really did not have any solid policies in dealing with tribes. It was pretty haphazard and in many cases not definable. Not all Native Americans lived on reservations. Probably as important, not every tribe had a reservation. And to complicate things further, there were non-natives owning land on reservations, particularly in the Northwest. There was a checkerboarding effect that went in at that time. And so we had a real non-definable or non-workable situation in in the United States dealing with Native Americans. And one of the very important parts of this relationship is that American Indians, Alaska Natives, were not citizens of the United States, and so they really did not have a lot of political power. They had to rely upon their friends or people that were empathetic to the concerns of Native Americans in order to have reasonable power. And so when you don't have the right to vote, you don't have the right to participate in the development of public policy, and you can't own land, you find yourself pretty much at a disadvantage in dealing with the federal government, or even, in our case, the territorial government. And so our people, all Native Americans, not just here in Alaska, but throughout the nation, really felt it was important for Native Americans to be recognized as citizens. Now let me back up a little bit and state that in 1887, people could become citizens of the United States under the Dawes Act, but they had to relinquish their way of life with their tribe and separate themselves from actually the tribe as it existed. So you basically had to vow to abandon your native way of life and your tribe in order to become a citizen. And in 1915, our territorial legislature adopted a similar policy. In Alaska, the Alaska Native Brotherhood was very active in this debate and participated on the national level on trying to not only advocate for citizenship of Native Americans in the lower 48, but also include Alaska. And in 1924, Congress did pass the American Indian Citizenship Act that allowed Native Americans to become citizens without having to relinquish your relationship with your tribe or having to give up your tribal way of life. In the early 1930s, the federal government realized that it was probably in the best interest of everybody if they established laws that would clarify who was a tribe and who was not a tribe. And in 1934, the Indian Reorganization Act was passed. This act had two sections that were very important to tribes. Section 16 was the governance component, which allowed tribes to formulate their tribal government. The downside of that provision was that when they implemented by taking those articles of incorporation for nonprofit organizations and turning them into constitutions, and it was pretty much the same verbiage for all the IRA tribes, particularly here in Alaska. The other provision, section 17, gave the tribes ability to establish and incorporate businesses under the tribal name. And in Southeast Alaska, this was very important because we were very active in the fishing industry, and we had communities that chose not to incorporate under or to adopt constitutions and function as governments. They chose instead to operate as businesses and corporations. For example, in Klawock, kind of where I'm from, the Klawock IRA not only purchased a cannery, but also operated a lot of their boats under their IRA governance, their corporate governance. And in Ketchikan, they had a similar philosophy. They even named their tribal government the Ketchikan Indian Corporation. And that was their first name. They are now Ketchikan Indian Community. And so they intended very much to do business under their tribal authority, the Section 17 of the IRA Act. The other thing that is a result of the IRA is that there then became over 220 recognized tribes in Alaska. A very important beginning that I'll get into a little bit later here. But let me go back to Southeast Alaska. During this very same point in time, matter of fact, just a little bit before that, in 1929, the Alaska Native Brotherhood Grand Camp voted to sue the federal government for the taking of the Tlingit Haida lands, or Southeast Alaska, without the permission or concurrence or even compensation for the taking of our land. And if you're familiar with our Constitution, the United States Constitution, you're really not allowed to take land without due compensation. And that was a very important provision of the Constitution that allowed our case to go forward into the future. And so the Court of Claims heard the case and determined, well, we really don't know how to deal with the people of Southeast Alaska because they are citizens, and suing the government as other citizens would do. You really have to be a tribe in order to have Aboriginal land claim rights. And that's a provision that is required at that point in time. In order to sue for Aboriginal land rights, you really had to be a tribe. You couldn't just be citizens or an organization like the Alaska Native Brotherhood. And so the Alaska Native Brotherhood petitioned Congress to get recognized, get our people in Southeast recognized as a tribe. And in 1935, the Tlingit Haida Jurisdiction Act was passed. That solidified tribal recognition for Tlingit Haida. It did not grant any land or any settlement or anything like that. It simply recognized Tlingit Haida people to go forth in the suit against the government for the taking of our land. That recognition is very important for Tlingit Haida Central Council today. I won't really get too deep into that, but I wanted to give you a little bit of that history. Today, I've been asked to talk more about the interrelationships between tribes and corporations. And while I think that those of you in the room may be aware that there are some conflicts between tribes and corporations, maybe not so much in our region, but in other regions, I think it's important to point out that when ANCSA was passed into law, most of our people celebrated the passage of that act. We felt it was long coming, long suffering, and it was in line with what we felt was due us. And now, getting back to the IRA tribes, and I'm going to get to some of the skirmishes a little later, many of the IRAs by that time had become somewhat dormant, if not entirely. Now, I'm not going to be able to paint everybody with one brush, because many of the IRAs that had canneries, that had boats, fishing boats under their IRA corporations, still functioned. They didn't function as governments, but they functioned as businesses for their tribe. Now, the reason I mention that is because there are a substantial number of tribes westward that are really quite vocal about their attitude or philosophy about what ANCSA did or didn't do. I'll get to that a little later. When we look at a little bit of history after that era, we need to understand what revitalized tribes to be what they do today. And that was revitalized by what was commonly known as the Indian Self-Determination Act. That act was passed in 1975, and it required the federal government to enter into contracts for the programs that the Bureau had for the benefit of Native Americans. It required them to enter into a contract. It didn't say you may not, or there's authority. It said you must, if the tribe wants to contract for a service that the government has for its people, you must do that with them. You must enter into that contract. That gave a lot of substance, if you may, to tribal governments across the nation. And here in Alaska, when that act was passed, the very first definition that was included in the act included ANCSA corporations. It had villages, and it also included village corporations and regional corporations. And it was recognized very early on that that was going to be a problem, because you had within communities the existence of IRA organizations, while you had also corporations formed under ANCSA. And you also had regions that had tribes in them, and regional corporations would be in conflict with some of the smaller tribes. So what the Bureau did is they established what is known as the order of precedence. The order of precedence, in its simplistic terms, said that if there is an IRA tribe in a community, that would be the first level of recognition, and they are allowed then to enter into a contract, or they're authorized to enter into a contract with the Bureau of Indian Affairs. In the event that there is no IRA, but there is a traditional council in that community, then that traditional council will be recognized. If there is neither a traditional council or an IRA in a community, then the village corporation or the ANCSA corporation from that for that village is authorized to enter into a contract. And if none of the above exist in the community, then the regional corporations would be authorized to contract for services for that community. That was a very good rule at the beginning, and helped us set up a fairly orderly and manageable approach to managing BIA contracts. However, it really was only for the purposes of contracts. We were left out of the Federal Register. The tribes in Alaska were not included in the list of tribes in the Federal Register. In 1993, Ada Deer became, she became Assistant Secretary in 92, but in 1993, she, I guess through her authority, added all of the Alaska tribes that were formed under the Indian Reorganization Act and those that were recognized as traditional councils. She put them all on the list of federally recognized tribes. And we all celebrated that for a while until we found out Tlingit was left off the list. And so we petitioned Congress to turn that around and made a good argument. So in 1994, our tribe got reinstated as a recognized tribe and are back on the list. The other thing that act did was it prohibited the administrative branch of government from removing tribes without first consulting with Congress, and of course then also consulting with the tribe that would be left off the list. And that's pretty important. That's a pretty important provision because of some of the tribes that are struggling with their existence, not only here in Alaska, but outside of Alaska. I'm going to now talk a little bit about some of the conflicts. Many of the conflicts are what I call skirmishes, but misunderstandings is probably as an important term to use in this discussion. It has come about in the last 10 years. I would say that there were a few little dissatisfied groups prior to that time, but they were more dissatisfied with the government or with the regional nonprofits. It was only in the last 10 years that more of the tribes westward became very, I guess, verbal about their feeling that ANCSA was a termination act. Termination in the sense that when ANCSA was passed, it did not give the land back to the tribes. It gave it to a state-chartered entity called a corporation. And so some of those folks that were anti-ANCSA felt that, well, if we get rid of ANCSA, then the land probably would go to the tribes. That really is very far-fetched and, if not impossible, simply because of the politics, but probably more importantly, the issue of land designation for tribes and tribal lands as it deals with trust lands. So it really, that's one point that was being made. Another point that is made by some of those very same tribes is that, well, because their region does not allow for descendants of original shareholders to become shareholders, that as the years go by, they will no longer have shareholders. And I agree with that summation in general terms. However, they can individually will them on down the line to their children and grandchildren. But it is really up to them. They have the right, they have the option of opening up the rolls as Sealaska did. And so to try to change federal law to satisfy their inability, I think is counterproductive, not just for them, but for all of us. Because it creates a debate that we really had done way back in 1988, and we really don't need to have that debate again because it's more divisive than productive. I think that when you look at ANCSA as an instrument to do what it did, to bring about the kind of things that ANCSA did, in, not just in the development of business, but also in the development of people, I think you will have to admit that ANCSA was one of the biggest and most aggressive settlements in the nation when it comes to Aboriginal lands and the lands of the people and the rights of the people, the Native American people. And when I say about people, you don't have to look far to see many of our shareholders that have progressed up the lines in the corporations, have left corporations and done things with other businesses. And that largely is a result of the benefit of the Alaska Native Claims Settlement Act. One of the biggest debates up there westward is the issue of subsistence. Because there is provision in ANCSA that terminated the hunting and fishing rights of Alaska Natives, the feeling is that if we got rid of ANCSA, that those rights would return. While I generally agree that we can probably get rid of that one provision and it would improve things, I don't agree with the act that you have to throw everything out in order to accomplish that issue with subsistence. I generally agree with the NILCA, but I mostly agree that that provision of ANCSA is contrary to international dealing with Aboriginal peoples, that they mostly sustained or retained those rights over time, even though there was a dominant government coming into their homeland. Here in the United States, here in Alaska, that's a little different. Even tribes in the lower 48 are working on cooperative agreements with parks, etc., for their Aboriginal hunting and fishing rights. And most of you are familiar with, of course, the Bolt decision down in Washington, where they actually get half of their fishing rights, or half of the fishing allocation for Native Americans in the Puget Sound area. So it really is, I think, a provision of ANCSA that is very negative for a people or a group, a society like we have in Alaska that is primarily dependent upon subsistence. When you look out in rural communities, the dependence on subsistence is very keen, and so therefore that's why the emotions are so high out there in western Alaska, where subsistence is really a big deal. I think that it's important to also talk a little bit about things that corporations are struggling with that create some negative thoughts from the tribes. There's a feeling that federal recognition of tribes should be extended to ANCSA, and there are reasons for that. The biggest reason, of course, is eligibility for the kinds of programs that tribes in the lower 48 take for granted. They are eligible for example, in forest management. They get certain access to federal agents by having agreements under the various laws that deal with those kinds of issues. There's the issue of consultation. There's the issue of things like NAGPRA, that corporations would most likely be able to do a lot more with had they the eligibility. One proposition that came up at the Alaska Federation of Natives meeting that we had some discussion on was the proposition to have ANCSA corporations gain full voting rights in National Congress of American Indians. On the surface, that sounds like, well, we just want to be equal as a Native organization. And I agree that that's a good argument. The negative side of it from the tribal side is the issue of organizations that are built around tribes that have been determined to have tribal sovereignty. The issue of tribal recognition based on the list that is published in the Federal Register and things of that nature. So anyway, one of the arguments about weakening the status of tribes is pretty important, because you got to go back to some of the early discussions I had about the recognition. The government-to-government relationship with the United States versus with a tribe is based on the reality that those tribes are made up of Aboriginal peoples, people that are primarily from that homeland where they are being recognized. The other dimension is it's made up only of those Aboriginal peoples. The other dimension is, of course, the recognition through a federal process. I talked about the Indian Reorganization Act, for example. Those are federal instrumentalities by which they use to recognize tribes. In the case of ANCSA, they are incorporated under state law, and I'm married to a non-native and I die, and there was a probate, she would get at least half my shares, if not all of them, under the way ANCSA is now. And so we have the issue of then a non-native owning shares of the Sealaska, Sealaska Corporation shares, and also Sean Seat. Now, it's not going to happen in our household because I already have written out who that goes to, and she agreed with me, by the way. So that's not going to be an issue in my household, but it has happened where we have situations where the original shareholder died and non-natives own the stock. So those are two elements of tribal recognition that would somewhat water down the issue of the government-to-government relationship with the federal government. Now, it could be argued, well, amongst ourselves we can make it work out. However, you need to be aware that even this past year, our state legislative body wrote a letter to the Secretary of Interior suggesting that we don't have tribes with any sovereignty in the state of Alaska. And so therefore we need to, the federal government needs to rethink how it deals with the tribal governments that they recognize for the purpose of tribal courts, etc. And we do have some active non-native non-native attorneys that have spent their whole lifetime doing things that are against the best interests of tribes and Alaska Natives. And so to give more ammunition to that debate, that discussion, really is a risky proposition from the point of view of the tribal side. Let me talk a little bit about the issue of consultation. ANCSA corporations have very frequently talked about the problem of government-to-government consultation, excluding them, particularly on land management policy issues, economic development issues, energy issues, and also subsistence issues. And the tribes argue that government-to-government consultation should be only between the federally recognized tribes and the federal government. And my position is I agree with both. I'm not running for Congress, but I agree with both sides. Let me tell you why. I agree that on those issues that the corporations need to be consulted on, we should have a policy that allows that. But we need to take out the term government to government. The government to government should be between the tribes, and consultation with tribes on tribal issues, the more things that are dealing more with the Aboriginal issues and the contracting over services should be between the federally recognized tribes only. And I think that some of the arguments that come forth from the tribes up north is that they feel, well, gee whiz, if corporations need to have consultation on land issues, they should go through the tribe. Well, even in today's society, on those issues that are primarily governmental in nature, we don't get proper consultation on already. And to somehow think that, well, the government's going to change its mind and now we're going to consult with you on another variety of issues that we choose not to, we're going to somehow turn that around and open that up. And that's really not a reality. One of the things that I did say up at the AFN meeting, and I don't know that anybody took it serious, but I made the statement that government-to-government consultation is not a panacea in the meaningful relationship between Native Americans and the federal government. What I mean by that is that very often throughout the years we have brought up issues that are very important to tribes and Native Americans, and nothing's been done about it. Let me give you a couple examples. In 1975, we realized that not all government agencies paid 100% of indirect costs as required by law. We've been arguing about it since then, and we still don't get 100% of the indirect costs that are due us as a matter of law. Let me make another point here, is that there is no federal law prohibiting Alaska tribes from taking land into trust. We've been debating that for over a decade, almost 2 decades now, that the regulation that says except in Alaska was put in there during the Venati era and was never taken out, and nobody will change that. Now, we've been consulted by the administration on it, we've been consulted by Congress, but nobody wants to move on that. So is consultation meaningful, or is it just a forum by which somebody needs to hear you say it again? Tribes across the nation have constantly stated over and over again that funding to its programs should be based on need and not some formula established by OMB. And that hasn't changed. As a matter of fact, because there was a perception that Native Americans pretty much got what they wanted, from 1982 on, we have lost ground about 4% per year, whatever the inflation rate is, instead of growing as the federal budget has grown to satisfy other non-Native issues. And you know, this is not something that I'm talking about the top of my head. It's something that we've been debating for a long time. As a matter of fact, the Government Accountability Office did a study back in 2000 that verified what I'm saying, and that's where I got my information. The other is that for Alaska, again, we've advocated for a long time that one representative to represent approximately 230 tribes is not realistic when we have national forums. Now we're coming up to a meeting with the White House next week or 2 weeks from now, and we get one representative from Alaska. We get one representative from Navajo. Navajo's one. There's one representative for 230 tribes in Alaska. Now the mathematics is not off. The philosophy is way off. It's not really realistic for one person to speak for all 230 tribes as suggested, particularly if there's differences of opinion with other regions and other tribal groups. Now, I'm going to wrap up here shortly, so don't yawn too hard. But let me let you know what I concluded. After being involved in this for nearly 30 years now, maybe a little bit more, started when I was 12. The government or the federal agencies want consultation, number one, when it has already made up its mind and needs to go out and tell you about it. And number two, they don't intend to do anything anyway. They're just saying they want to say that they went out and talked to tribes. Number four, they can't figure out what to do, and then they need some sort of scapegoat to say, well, gee whiz, well, the tribes can't figure it out. Why are we asked to do it? And also, they also need a forum. Sometimes they do have a forum whereby they're telling you something good. It's not all negative. But the reason I say that is because I have a much more extensive list on things that we've consulted with the government on over the years, and nothing's been done about it. Even the policy on consultation under the Obama administration, it was announced in November of 2009, and we still haven't gotten it published and approved. The lawyers are still looking at it. That's an example of how we get thrown into this issue of consultation, expecting that something's going to get done and it doesn't get done. The reason why I feel that tribes and corporations need to work closer together is because of the status of our people in our territory or in Alaska. We have very weak rural economies. We have high cost of energy that leads to higher cost of living, higher cost of survival in our communities. And so when you have a weak economy and energy costs go up and the cost of products in your store, you really have to make a choice on whether to stay there or not. Another reason why we should work together is because we have better strength in dealing with the federal government when we're united, and we need to address some of those impacts of our budget cuts. One of my pet peeves is the absence of anything being done about subsistence. When the Secretary of Interior came to Alaska, he made a speech to AFN and said, subsistence in Alaska is broken.